morning, everyone. My name is Rya Stone, and I'll be your host and presenter this morning for a mini webinar for top 3 HR and legal considerations when managing remote work employees. Thank you so much for joining us today. I'd like to start by introducing the core members of our team that you'll be working closely with when you're working with ClickOnHR. First off, we have Elizabeth Fletcher, our wonderful HR manager. We also have Melanie Hernandez, our recruiter, who handles all of our clients' talent acquisition needs at a world-class level service. Hope Deanda is also our wonderful HR assistant, and we have myself hosting this meeting today. If you have any questions, please type them in the chat box of our Q&A, and Elizabeth, our HR manager, and myself will get them addressed at the end of this mini webinar. Since it's a mini webinar, we will save all questions for the end, as it allows those that would like the opportunity of the webinar to exit if they don't want to stay for the Q&A portion. As we're all aware, workplaces are changing quickly and dramatically this year in response to COVID-19. And among many of the changes, one of the more immediate ones have been employers allowing employees to work remote, and the majority of the times from home. This definitely presents some challenges and considerations on the HR and compliance fronts. I'd like a second to emphasize how critically important it is for us to review these exposures for several different reasons. The first one being that the government agencies are passing a lot of employment laws in a very short amount of time to address the COVID-19 emergency disaster. Secondly, in a classic trickle-down fashion, we're seeing a tremendous amount of activity at the state, city, and county levels from the initiation of the federal level standards that are coming down in a trickle fashion. So why review? Because legal experts are expecting a surge in litigation in the upcoming months. First, because the laws are getting more and more complex, which means employers are more and more likely, similarly, to make mistakes in misinterpreting the FFCRA regulations or CARES Act or any other legislative pieces. Secondly, when times get tough, employees are more likely to find fault with their employers to take legal actions. Today, we're going to share some critical challenges and offer some strategies to manage them. The items we will cover are remote workplace policies. These include what type of work policies to implement or update around confidentiality, privacy, etc. Second, we're going to cover COVID-related leave requests or mishandling of them, how to handle it correctly based on the FFCRA that was passed earlier this year. There's certain keynotes you want to be made aware of. Third, we're going to cover managing remote employees, specifically non-exempt employees. We'll cover best practices and recommendations around this topic, making sure that you don't pose a risk to your company by violating time, keeping, or wage and hour laws. So let's dive right into HR and compliance exposure number 1, not updating your remote work policy. Not every organization has one, since many of you may not have remote employees, so don't feel too bad if you don't have one, but let's get moving on it. Neglecting to update your remote work policies can cause exposure to your company, and we're going to cover why exactly. Remote work creates unique situations, and not every job can be done effectively in a remote environment, and I think we can all agree on that. When exactly should employees be working when working remote? That's a big question that we hear a lot. It can also bring in new and unplanned risks, such as confidentiality and privacy issues. Ultimately, you want to protect your organization. This holding pattern of working remote can become our long-term reality, so you want to plan or consider certain things when updating this policy. Here's why. You will want this policy. First, you'll need to create this clear boundaries and expectations for your employees. Second, you'll want to avoid misunderstandings and misrepresentations. Last but not least, workplace policies need to evolve alongside current environmental, health, economic, and legal trends. There are several items you should take into consideration as you update or draft your remote worker policy, and we're going to cover a few of them. You want to outline your remote work criteria and your employer control of remote work decisions. So define the criteria for what jobs really qualify for remote work. Is it part-time? Is it full-time? Is it ones that work in accounting? Is it ones that work in supply chain versus sales? Or in HR for that matter? So which jobs are really eligible for remote work? Second, reserve the right to end the remote work arrangements whenever the business decides it's no longer needed or required. Also, how will alternate work schedules make a play in this? Meaning, if you're having people work 3 days from home, 2 days at the office, how will that coverage quite work? Next, be sure to review also the rules for access to business locations or facilities. If any of the facilities are restricted because there's a positive test in the building or in the facility, then how will that affect the communication and the remote work strategy and next steps into making sure that everybody is working remote effectively? You'll also want to review the use of company provided equipment or how employees can request company equipment when working remote or how they're planning on bringing home the equipment when working remote. More and more employers are allowing the employees to bring home their printers, scanners, and other equipment. So while you keep inventory, which is key in making sure you know which equipment is assigned to which employee, it's also important to outline the use of the equipment of the employees, meaning how should they care for it? What steps should the employee take if an equipment is lost or damaged? Also, be sure to define the work schedule and availability. What that means is if we are specifying that the hours employees are expected to work or be available to work is from 9 to 5 or blanket 8 to 5 or whatever that might be fair about it. While we understand that one size doesn't quite fit all, the policy should be fair across the board to accommodate any exceptions, but while presenting a sense of fairness. So what is expected when it comes to responsiveness with coworker requests and exchanges? And it's a good way to track it when you know that somebody's by their laptop and they're responding back to a coworker request in 20 or 30 minutes. But what about client interfacing roles, typically that are not tied to the 8 to 5 desk job? How do their work hours really differ and is their responsiveness measured to the client's expectation? So those are some of the things that you'd want to think through and proceed accordingly. You also want to review your overtime restrictions and approvals, which is a pretty big deal, and that you may already have existing overtime guidelines. But if thanks to COVID-19 this year, if everyone is in a temporary no overtime, no exceptions policy, how has this been communicated? What are the repercussions, and what are now the new updated and specific guidance into asking for overtime approval during emergency remote work? Since there's a lack of visibility, it's harder to get the approvals, and how will that now look for hiring managers or departmental managers? Last but not least, consider your technology, data security, and confidentiality language. Make sure that you establish basic minimum requirements such as buyer's protection for phones or internet service or laptops are updated. It's still the employee's responsibility to make sure they liaise with the IT department to get all that updated if anything is out of order, because the last thing you want is a virus or a hack or a ransom hostage situation for intellectual property. Address also how employees should handle sensitive information at home, if they're printing anything out, what is the shredding policy, or protecting the confidential company information. Most of all, remind all employees that all other current policies are still in effect. Let's move into risk number 2, which is mishandling COVID-related leaves. As I mentioned earlier, with a lot of new legislation being rolled out this year, the more understanding we have, the less the risk of employers being negligent or mishandling leave requests that are COVID-related. Please be on the lookout for any state level and county level requirements as well, because those can be different, and you will want to make sure that you are accommodating the compliance requirements at all levels. Diving into the Family First Coronavirus Response Act, which is FFCRA, you may hear me say this a few times in this meeting. It was signed into law March 18th, effective April 1st. It's a temporary emergency measure that expires end of this year on December 31st. Its extensive legislation covers many aspects of the COVID-19 or federal COVID-19 response. The two main key parts affecting the employers are Emergency Paid Sick Leave Act, which is known as EPSL, and also Emergency Family and Medical Leave Expansion Act. You may know this as FMLA, and this is just basically an expansion act in this part of this FFCRA. We'll cover emergency paid sick leave in this slide. Basically, it affects private employers with fewer than 500 employees, as well as most public employers. There may be caveats to employers with less than 50 employees that may not be able to afford the Emergency Paid Sick Leave Act, and you should definitely do some research on this if you belong in that group. The Emergency Paid Sick Leave Act provides up to 80 hours of paid leave for eligible employees who cannot work even remotely because they're experiencing any other substantially similar condition to COVID-19 per Secretary of Health and Human Services. Now, I want to highlight substantially similar condition because it doesn't have to be COVID-19. If they're experiencing anything similar to it, this leave may be applicable for them as well. Examples are if employees are experiencing COVID-19 symptoms and seeking diagnosis, and if they've been advised by the healthcare provider to self-quarantine due to COVID-19, or if they've been asked to self-quarantine due to federal, state, or local government quarantine order related to COVID-19. Those are some key items to keep in mind. Additionally, the law provides leave for employees who cannot work, even remotely, because they're caring for an individual who is subject to mandatory government quarantine order or advised by a healthcare provider to self-quarantine. Now, I want to broaden upon this fact that, or this item, that it doesn't have to be a child. It can even be an elder or an adult. So it can be a family member who requires medical assistance at home. Or if they're caring for a child whose school is closed because of COVID-19 emergency. So those are some of the examples that can fall under this Emergency Paid Sick Leave Act. The most important thing to note here is that emergency paid sick leave under FFCRA is in addition to any existing sick leave or paid time off already offered by the employer. Meaning, if you're already offering your employees 14 days worth of sick time, this expansion or this emergency paid sick leave is in addition to that 14 days that you may already be offering for your employees. So just some critical areas to keep in mind that helps you with not mishandling any COVID-related leaves. Next, we'll move into the second leave act that's part of the FFCRA, which is the FMLA Expansion Act. The amendment to the Family and Medical Leave Act basically affects private employers with fewer than 500 employees and certain public employers again. It provides the extended paid FMLA and job protection employees who are caring for a child whose school or place of care is closed during COVID-19. Now, many of you are already familiar with FMLA, and here's how the Expansion Act is different. Unlike FMLA, this Expansion Act does not require a minimum of 50 employees within a 75-mile radius and only requires 30 days of employment to qualify. So you don't have to be employed for a full year like your classic 12 months or 1250 hours to be qualified for FMLA leave. For this FMLA expansion leave, you can actually go ahead and qualify for it after 30 days of employment. And that's something to keep in mind. And it can affect any small employers below 50 employees as well. So this is something really critical, which is different from your paid expansion or your expansion leave for the employee paid sick leave, basically. So if you need any additional help with this item, feel free to contact us for complimentary forms or resources because the documentation showing COVID-related leave is going to be critical in being able to substantiate your why you approve the expanded FMLA Act, basically. Now, you may wonder if there's a silver lining in any of this at all. The silver lining is that the federal government will reimburse the cost of qualified COVID-related leave and the financial relief that it will come to you as tax credits. So make sure that you keep proper documentation to prove that the leave meets FFCRA criteria. So basically, when you do the Expanded Family Medical Leave Act, ensure that you're documenting the lack of daycare or the lack of another family member at home that can take care of this person, and that's the reason why they need to leave. So that's something critical to document in your FMLA paperwork for this. Now, the third risk we'll cover for remote work employees is how to manage them if they are non-exempt. So working remote complicates supervision, guidance, and oversight into their day-to-day tasks, and any changes to pay and hours only further complicates things. As we all know, non-exempt employees must be paid at least the minimum wage for all hours worked, which is basically your hourly employees, and 1.5 times their regular rate for hours over 40 hours. All employees are considered non-exempt for exempt status under FLSA. Now, exemptions are based upon the job duties and the minimum salary amount, which is $685 per week. Now, if we have the non-exempt employee being affected by pay reduction or or change in rate of pay, there are certain critical items you want to consider. Ensure that, if it's allowed, if the minimum wage meets requirements, consider the highest applicable rate for state, county, or city. Be sure to review the contractual collective bargaining obligations and discrimination laws. Now, let me expand upon that. What that really means is, do you have anything in the offer letter that would prevent you from changing the rate of pay? Or are they part of a union? Or is this change of rate and pay affecting the entire group? Or will you run into any discrimination issues for singling somebody out? And you also want to make sure it complies with state and local notification rules. Now, I'm going to cover notification rules a little bit further in this webinar about what that actually means and how that can affect you. Now, if there's a change in scheduled hours, the change or reduction allowed must be made due to temporary closures or reduced demand, and must comply with the predictive scheduling laws, which is the part that we're going to cover in a little bit about the notification of scheduling laws. Now, if you also provide your non-exempt employees with a fluctuating work week option, meaning they are basically on their time card automatically entered in for 80 hours, and if they go into overtime, you pay them on a reduced basis or reduced calculation method, but if they go below 80 hours, you're still paying them for 80 hours. Now, there are some states that allow this and federal guidelines to allow this. Then you want to ensure that you calculate correctly the overtime using the reduced calculation method and keep accurate records of all hours worked. So it comes down to record keeping and making sure you're monitoring a lot of these items. Now, the remote workers and predictive scheduling laws, which I mentioned earlier, basically there are certain states and cities that require employers to provide employees with advance notice of their schedule. In some instances, you will also be needing to compensate your employees for last-minute changes. This specifically applies to Oregon, San Francisco, Emeryville, New York City, Philadelphia, Seattle, and Chicago right now. Failure to comply is going to result in a fine of $500 per employee plus legal damages. Now, legal damages include your unpaid wages plus liquidated damages and the fines of $500 per employee. So you definitely don't want to risk that. So if you're doing a pay reduction or change of rate and pay, or change in scheduled hours or reduced hours, or ensuring that you're modifying their work week or anything, you want to make sure you consider these items before you plunge in head first. So those are some of the items that you'd want to consider. Now, working remote or from home, the lines can be incredibly blurry for hourly employees. It can get tricky to monitor mandated lunch breaks or rest breaks. Here are some considerations that you should think about when managing remote non-exempt workers. Ensure that you specify explicitly, even though you may have done in the past, that anything that is not work-related or off the work hours should not be during on-the-clock work hours, because they're technically not exempt employees. So having a strict or stricter time frame that they'll be working with is going to be incredibly important for you to manage the workforce. Make sure that you brush up also on traditional hours regarding hours worked, meaning, is training considered hours worked? Is seminars considered hours worked? What if the systems are down and the time waiting, is that considered hours worked? Those are some things you want to specify with your non-exempt employees and communicate accordingly. Now, off the clock time, this is a critical item that I do want to cover. Meals and breaks, meal breaks and rest breaks that are mandated by state, federal, or city laws. Now that they're working remote, how will you now manage how they're clocking in and clocking out and inputting also the hours that they're taking for the mandated breaks? So for example, if a remote worker is now not inputting the time according to when they take their rest breaks, how will we now document that? So there's some monitoring there that could be helpful for the company overall. Make sure to avoid any automatic deductions for meals or breaks, which is what leads me to the prior point that I made, meaning don't automatically input 15 minutes twice a day into their time cards. That can be a violation of wage and hour keeping laws. Clarify expected work hours and the breaks as well, and it can vary by role and department. Allow some flexibility and make sure that you use the electronic system for clocking in and out. And also try not to do an automatic upload of the timesheet that automatically put in the 80 hours for them as much as possible, and require some overtime approval. So those are some of the things that I wanted to cover around some of the risks that you might have when managing a remote workforce. Now, with that, wrapping up today's session, and we can now begin addressing any questions you have right now. All right, we have a question from an attendee. Do I have to provide the additional time even if I only have 10 employees? The additional time for I'm assuming based on the question, for the Emergency Paid Sick Leave Act, and the answer is it depends. If you're financially stable enough to show that you are able to afford the paid sick leave, then yes, you will need to go ahead and provide the time and document it for tax credits. Now, if it's for the expanded FMLA, then yes, you definitely have no exceptions. Even if it's below 10 employees, you will need to provide the expanded FMLA Act based on the regulations that have been passed. The next question we have is, a supervisor required to get this information of leave, or is this confidential? Great question, by the way. The answer is you want to keep this information confidential. And the reason for that is because for one, confidentiality and HIPAA laws, we don't know if the leave is because of COVID-related items or health-related items, or it could be a completely different FMLA item that we are not aware of. So you do want to keep your classic confidentiality clauses in place regarding HIPAA and compliance actions. And secondly, which is a little bit more important, as we are navigating this incredibly tough COVID-19 landscape this year, if there are any changes to furloughs or layoffs or modified work duties, you certainly don't want a violation or breach of confidentiality to come back, in which if you do lay off an employee or reduce their work hours, it affects them adversely, and they get to bring up the fact that their supervisor is notified of the fact that this is why they needed the expanded leave or any of the modifications. So I would say maintain it for both confidentiality reasons and also to make sure that you protect the company from any potential liabilities in the form of breach of confidentiality and adverse impact, basically. Another great question. Is it confidential that an employee, is it confidential information that an employee be required to be informed of the positive test results of the employer? The answer is it is not required that you report it to your employer at all. However, it would be in your best interest to do so, just to ensure that if you have any critical illness or accident claims form, I would make sure that you communicate all that information directly to your HR department or your HIPAA compliance person within your organization to ensure that they are made aware and that they can ensure that your benefits are not being altered in any way. But the law doesn't require that you disclose that you have had a positive test result, but it would be in the employee's best interest to disclose it for all these paid leave and also from accommodation from the employer and also continuation of benefits if needed. These are some great questions. Well, I think that's all the questions that we have. I want to thank you, each and every one of you attending today. If you ever need any help, we're just a click away. We can be reached at info@clickonhr.com and 1-833-CLICK-HR. Please follow us on our social media platforms if you already haven't done so. And thank you and have a great day.